statement na yan. Parang nagko-call for no, parang sabay kayong gaganan.
The continuation of this impeachment trial of the Honorable Chief Justice Renato C. Corona of the Supreme Court is hereby called to order. We shall be read in prayer by Senator Ferdinand Bongbong R. Marcos, Jr.
Let us all put ourselves in the presence of the Lord. Almighty God and Father, we come to you today to thank you for the manifold blessings that you have granted our nation, a nation that must remain united despite the growing voices of discord. As we resume our work today, may we ask for your continued guidance and mercy. May we, the senator judges, be fair and decisive in our actions. Remind us of our responsibility and accountability to the people. Give us the wisdom to make decisions that will strengthen and inspire our nation. Touch the hearts of all here before you now. Heal the wounds of division and conflict, and open all our hearts and minds to find and to listen to the truth. Above all, dear God, we pray for the Philippines. Clear the minds of all from confusion and anxiety so that we may clearly see what is reality and what is not. In these trying times, cause our leaders and our people to strengthen their faith in God and in country. And may the Holy Spirit always give us hope in these trying times as we pray all these in the mighty name of Jesus. Amen.
The Secretary will now please call the roll, Senator.
The Honorable Senator Judges Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon, Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Ligarda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revillas, Soto, Trillanes, Villar, the Senate President.
With 17 senators present, senator judges present, the presiding officer declares the presence of a quorum. The majority floor leader,
Mr. President, may I ask the Sergeant at Arms to make the proclamation?
the sergeant at arms will now make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority floor leader.
Mr. President, I move that we dispense with the reading of the May 7, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the May 7, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. The Secretary will now please call the case before the Senate.
Case
sitting as an
number
impeachment court.
0022011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Majority floor leader.
Mr. President, may we ask the parties or respective counsel to enter their appearances, prosecution and defense.
Good afternoon, Mr. President. For the House of Representatives Prosecution Panel, same appearance. We are ready, Your Honor.
Noted. Defense.
For the defense, Your Honor, the same appearance, we are also ready.
Noted.
Mr. President,
The majority floor leader.
before the business for the day, may we recognize Senator Edgardo Angara?
The gentleman from Aurora has the floor.
Thank you very much, Mr. President. Mr. President, late yesterday afternoon, when we have a break in the session, I was handed a copy of a motion seeking my inhibition, and I read it very carefully, Mr. President, and I wanted to stand up even then to reply point by point to the false allegations contained in that motion. But unfortunately, we didn't go through with the session because the defense was unprepared. But now, Mr. President, at the first occasion, I woke up this morning seeing the motion almost bannered by every newspaper and listened to the radio also bannering the story. It eclipsed, Mr. President, the family thrill at seeing my grandson, Edgardo Angara, 7-year-old, winning a tennis tournament at the Rizal Coliseum. So I would like you to read the Philippine Star Sports. Angara pulled through in first gen opener. Well, Mr. President, I'm not an athlete, but to me this is a source of thrill because my grandson, the son of Congressman Sani Angara, is only 7-year-old, and yet he joined a 10-year and under competition. So that's for the athletic skill of the Angaras. Mr. President, when we were convened as an impeachment court, we didn't seek this role. It was mandated by the Constitution that we shall sit as senator judges. And therefore, it's a constitutional task assigned to us, Mr. President, and I consider it as a constitutional duty on my part to act as a judge, and no argument, no persuasion can convince me that I should inhibit, because this is a duty I will not abdicate. Mr. President, I did not have a hand in choosing Sani Angara, my son, to be a spokesperson for the House of Representatives. The two houses are quite separate and distinct, co-equal. We honor their own respective processes. So I have no hand at all in telling anyone, please choose Sani Angara to be one of the spokespersons. But the worst thing about this motion, Mr. President, is the insinuation that, or the suspicion that I will be unbiased and unprejudiced because of that relationship. And this, Mr. President, the malicious insinuation that political favors have been extended to my province of Aurora, in effect insinuating that my vote has already been bought as a result, Mr. President. They mentioned, Mr. President, 3 major projects that was just recently approved by the NEDA. And of the 3, Mr. President, only one really concerns and was for Aurora, and that is the Baler-Casiguran concreting project. Mr. President, that project is not going to be funded by Philippine money, not by the savings and taxes of Filipinos. It will be funded wholly by the Korean government, Mr. President. I got that, Mr. President, 3 years ago during the past administration, not under this administration. The only thing that happened during this administration is that it was approved by NEDA, which is required for all foreign funded projects. The other 2, Mr. President, is a project, I think, of a circumferential road in Samar. I'm very thankful, and I'm full of admiration for those who were able to secure that, because Samar is such an undeveloped province, and putting a circumferential road like in Bohol would really make Samar a destination of investments and tourism. The third project, Mr. President, is the bridge over Umiray River. Umiray River, Mr. President, for those who don't know it, is the river in Aurora, base located in Dingalan, which supplies all the water for Metro Manila to Angat Dam. And that project, I hope I was the one who initiated it, but I did not, Mr. President. It was a project of Governor Suarez and Congressman Suarez, funded again by the Japanese government. not by our own government. And yet, Mr. President, the petitioners have the gall and the audacity to suggest that these are political favors for me. So I reject that, Mr. President, and I reject it as an unthinking and illogical conclusion that serves no purpose at all except to malign and make, I don't want to say it, it may be a diversionary tactic on their part, because you just scolded them, Mr. President, yesterday for their unpreparedness. But I won't say that. Mr. President, they also cited the application of the judicial the judicial rule, the Code of Judicial Conduct. Mr. President, even a first-year law student who knows how to read will immediately conclude that the Code of Judicial Conduct is not applicable to the Senate, much less to the impeachment court. We have our own set of rules, and the only code or rules we adopted as suppletory are the rules of court, Mr. President. So that is completely irrelevant and immaterial, Mr. President. There they say, my son is a party litigant. You see, even a first-year student will know that a party litigant is one who will suffer or benefit from a decision made. My son will not benefit from any decision either way. The only one who will benefit or suffer is our Chief Justice. And here are his lawyers who seem to devise a strategy of almost antagonizing half of this court, Mr. President. First, they want Senator Drilon to be inhibited. Then, Senator Gingona, they're pointing to Senator Pangilinan and Recto because they simply happen to be party mates of the President. Mr. President, many of us are party members. We are affiliated in one way or the other with one party or another. And all of us, except possibly one or two parties, are all supportive of government reform, of government program. Does that mean that the entire impeachment court is biased and partial? There is no other intention in these accusations of the defense, Mr. President, except to destroy the credibility of the impeachment court. I think that's the least that they ought to do, because this could be the saving grace in our democracy. If you destroy the one pillar of justice, the Senate, who can stand up even to the Supreme Court or the President, then you are really knocking down the very pillar that one day you may have to seek help and support from, because it can stand up to any person or institution. And to see how malicious this insinuation is, Mr. President, in their concluding paragraph, they said, the only way Senator Angara can redeem himself is to vote for acquittal. Mr. President, you know, I've been president of the UP, I've been president of the Integrated Bar, I've been president of the ASEAN Law Association, I've been honored by all of these organizations in various ways. I've never seen logic or legal logic like this. And therefore, Mr. President, I take umbrage at this malicious paper. My good friend Joker, when I showed him the petition yesterday, he said, Ed, don't answer it. It's not worth it, because you are doing a constitutional duty. They don't seem to appreciate that. And yet Joker is very sympathetic, and I can share his feelings towards the cause of the defense. So you see, as of now, But after this, maybe not anymore. So, Mr. President, I don't know. I have one outstanding alumnus of the UP College of Law, very able, very skillful, very eloquent, and can stand up in argument head-to-head with anyone. But he has one outstanding trait. He has a penchant for antagonizing the judge. So no client will now retain him. Because what's the use? You may have a good cause, but if you antagonize the judge, your cause is lost. No, I'm not comparing our set of defense, our panel of defense, to that one friend of mine who's brilliant, knowledgeable, eloquent, but has a penchant for antagonizing the judge. Thank you very much, Mr. President.
Thank you, Senator Angara. The chair would like to state for the record that we respect the opinion of others regarding each one of us or all of us collectively. But I assure you that none of you can sway us one way or the other. And if you have any reason to believe that we are dishonest, say so candidly and openly. And we are ready, willing, able to defend ourselves. So let us forget about this sad incident. Let's proceed with the case. Defense, present your evidence.
Your Honor, please, with the kind permission of the court, Your Honor, may I be allowed even one or more minutes, Your Honor, to make a little manifestation?
Proceed.
Thank you, Your Honor. Now, there had been some insinuation yesterday that the defense had been trying to delay the proceedings in this case, as evidenced by the fact that we have introduced quite a number of witnesses with no purpose and accomplishment whatsoever, Your Honor.
Who was making the insinuation? Was it from this court or from the... Anyway, let us be specific.
Well, that seemed to be our impression, Your Honor, that apparently
It was the court?
the defense was trying to delay proceedings, Your Honor.
Are you suggesting that it was the court that created that impression?
No, it came from the prosecution, Your Honor.
Well, that's the prosecution.
Yes, Your Honor.
All right.
And we wanted to be heard in connection therewith. Otherwise, we may be said to have acquiesced to that kind of a manifestation, Your Honor. If the records will be read, Your Honor, we have introduced quite a number of witnesses in connection with our defense, Your Honor. Some of them, they consist of 3 register of deeds, Your Honor, 3 assessor, city assessor, and provincial assessor, Your Honor. In so far as the register of deeds is concerned, we introduced them for the purpose of showing that there are no properties aside from those mentioned in the SAL, Your Honor, of the Honorable Chief Justice that belongs or were registered in his name. We cannot lump up only one testimony or only one register of deeds because the properties were located in different places. So, if we presented the register of deeds of Makati, of Manila, and Quezon City, it was never our purpose, Your Honor, to gain time in order to delay the proceedings, Your Honor. Not even the thought of it, Your Honor, but because we cannot do so. The register of deeds of Makati will be highly incompetent, Your Honor, to testify in connection with the records of the office pertaining to Quezon City and Manila and vice versa. That was our purpose, Your Honor. And we also introduced in evidence the testimony of the administrator of the Land Registration Office. From these statements obtained from them, Your Honor, on record, we were able to show convincingly, Your Honor, that the 45 real estate properties allegedly referred to be registered and owned by Justice Corona, Chief Justice Corona, Your Honor, does not all belong to him, but only 5 of them. Hence, it cannot be said that our purpose was merely to delay because apparently we could read from the records that even the court was convinced that actually there were only 5 or 6 properties that really belong to Chief Justice Corona. Now, how about the testimony of the various representatives of the assessment office, Your Honor? Now, we admit, Your Honor, we introduced 3 assessors, Your Honor. The city assessor of Makati, the city assessor of Manila, and the city assessor of Quezon City, on the same ground, Your Honor, because we cannot make one of them testify for the entirety of the properties not located in the respective places. So, if we presented 3 assessors, Your Honor, I hope we will not be misunderstood as trying to delay the proceedings, but it is because of our recognition that one is not competent to testify as to the other, and vice versa, Your Honor. Now, thereafter, we went further, Your Honor. We introduced in evidence the testimony of Ms. Araceli Bayugan, Your Honor, the finance officer of the Supreme Court, Your Honor, in order to belie and contradict the statement on record that there was no statement of returns of income tax return, Your Honor, made by the Honorable Chief Justice Corona, Your Honor, because from the testimony of the Honorable Commission of Internal Revenue, there were no returns, Your Honor, in arrest, Your Honor, for the years 2005, 2006, 2007, 2009, and 2010, Your Honor. We were able to introduce the returns, Your Honor, identified by our witness. They were duly marked. We took note of the trouble of marking the...
We know, counsel, we know all of that. It's all in the record. We are not accusing you of delaying.
Thank you, Your Honor, because that was our impression, Your Honor. We introduced these witnesses simply because to gain time, Your Honor. That's why we are placing on record.
I must admit that yesterday I said you are wasting the time of the court by introducing someone to testify or whether market fees are being collected from that market.
We are not in conformity with that, Your Honor, but the plan of the other lawyers came up, Your Honor, and we allowed him to take
Well, then you better advise your other panel that those things are irrelevant. We know what is an irrelevant evidence.
We did, Your Honor. In fact, I gave him a tongue lashing yesterday for the correction of all these matters that gave rise to the impression of the court. That is our only purpose, Your Honor.
All right.
Now, to contradict that and so on. Now, insofar as the Land Registration Commissioner is concerned, Your Honor, we called him to the stand in order to testify on the various alleged properties which he ascribes to be belonging to the Chief Justice. And we were able to elicit admissions, Your Honor, to the effect that they were not properties registered in the name, specifically in the name of the Chief.
Given, counsel.
Yes, Your Honor.
In fact, yesterday when Congressman Colmenares of the prosecution was asking for made a manifestation, the tendency of which was to reconsider the ruling of this chair on the claim that it will only prolong the proceedings, I denied it. So you can see that we are giving you all the time to defend the Chief Justice. We know that you are entitled to defend the Chief Justice. So the impression or statement of the prosecution is their position, but that is not the position of this court. That you are delaying. That's why we are asking you to wind up your manifestation so that we can proceed with the hearing.
Thank you very much, Your Honor, for the opportunity for being allowed to bring all these matters into the record in order to straighten at least the intention, the impression that may have been created, both public and upon the other parties involved in this case, that we were trying to delay. That was never our intention. Now, in connection, Your Honor, with the motion for inhibition, Your Honor, the motion was filed because of the feeling of the Chief Justice that at least he may not be able to obtain the recalled neutrality of a judge insofar as the subject of the motion is concerned. Now, What we did was to file it is up for the, we never stated that everything stated thereon are indubitably true, Your Honor. But we wanted to express, to give importance to the feeling of the Chief Justice in order that if a decision is made one way or the other, there is no doubt as to the impartiality and lack of bias on the parts of the deciding member of the Senate, Your Honor. Thank you very much, Your Honor.
Well, thank you for your manifestation. We now proceed with the trial.
Sige, tawagin. Yung witness na.
Do you have any witness?
Yes, Your Honor, we have. Sino? Alright. Tawagin mo. We, Your Honor, please, may we ask for authority for Attorney Roy to conduct the direct examination of the witness on behalf of the defense panel, Your Honor.
Granted.
Good afternoon, Mr. President, Your Honors. May it please the Court. During my presentation, I will present two witnesses who will testify, Your Honor, on the decision pertaining to the ownership of the Basa Guidote Corporation. I wish to state the relevance before we proceed because consistent with the mood of the Court, I wish to request for admissions. So if you will allow me some leeway, I wish to point out that
Proceed.
yes, thank you, Your Honor. The relevance of the ownership, of the actual ownership of the Basa Guidote pertains directly to matters stated in the SALN of the Chief Justice. It involves the 11 million pesos that was borrowed and repaid, and it may involve other acquisitions which may or may not have been drawn from the Basa Guidote funds. That is why we need to present these witnesses.
All right, proceed.
Thank you, Your Honor. May we call to the stand the Clerk of Court of Branch 216 of the RTC of Quezon City, Lucita Christie, Your Honor. Ano pa yung huli na babae? Saan? Where is it?
Please, Madam Witness, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this impeachment proceeding? Yes, ma'am. So help you God.
Your Honor, on the part of the prosecution, may we ask permission that Attorney Cynthia Corazon Rojas be recognized to receive the testimony and later on to conduct cross-examination.
Granted.
Thank you.
Before I proceed, Your Honor, I would like to invite the prosecution to admit the content for an admission of the substance of the of the testimony of the witness, which incidentally, Your Honor, also constitutes the purpose for which the testimony is offered.
Well, you better propound the questions first.
Your Honor,
If I were the lawyer from the other side, how can I
Yes, Your Honor.
agree with you
Yeah.
before you open your mouth to ask the question?
Yes, Your Honor, precisely. So, if this witness will proceed with her testimony, first she will testify that criminal cases Q96-68147 and Q96-68148 were heard before the RTC of Quezon City, and these two cases are cases for libelous publication, entitled People of the Philippines against Jose Maria Basa et al., the uncle of Mrs. Cristina Corona. Second,
Just
that-
for the record,
Yes.
Your Honor, may I be excused? We will stipulate on that matter.
Thank you. Second, her testimony is offered to establish that a decision of conviction was arrived at in these two cases dated September 5, 2001. May I have an
We will
admission?
No,
stipulate that.
sir, matters of record. We can even take judicial notice of those things. Just present them.
If you will allow me, Your Honor, it will expedite because it appears that the opposing counsel is willing to stipulate anyway.
Precisely.
We would be very happy if you would allow us to put this on record.
Okay.
Thank you, Your Honor. Third,
that a motion for reconsideration was resolved dated September 2, and that the same became final on October 12, both in the year of 2002, in both cases.
We will stipulate on that matter, Your Honor.
Fourth, that a writ of execution for the said judgment was issued on April 23, 2003.
Again, we will stipulate on that matter, the matter being matter of record.
Your Honors, inasmuch as all the matters, all the important points to be testified to by this witness have been admitted by the prosecution, we ask that the witness be excused.
Your Honor, please. May we be allowed?
Yes.
By way of counter stipulation, will the defense be willing to admit that insofar as the accused Jose Maria Basa is concerned, he died on August 29, 2002?
We have no knowledge, Your Honor, I'm sorry.
Therefore, would the defense be also willing to stipulate that during the pendency of the motion for reconsideration, which was stated by the good counsel of the defense, there was a pending motion for reconsideration on the conviction as well as on the civil award in favor of the private complainant in this
I'm
case?
confused. There was a motion for reconsideration.
You
When?
said that the motion for reconsideration was
Resolved.
ruled upon,
Yeah.
resolved,
And then went final on 12 October 2002.
yes. But it is during this period, and we're going to prove that on August 29, 2002, the accused Jose Maria Basa died.
I'm not aware of this.
If the accused is not willing to stipulate on this matter, Mr. President, I'm afraid that we should allow the defense to present this witness.
Yeah.
Let me just verify. I'm unaware of Mr. Basa's death. Personally, I cannot.
But this is born of the records. This
it
will
on
be
the
part of
record?
the cross-examination.
All right, we'll stipulate that he passed away on August 29, did you say?
I thought you had no knowledge.
No, personal, Your Honor. She says it's on the record. I'll take her word for it. Anyway, the records are here. Clerk of court is here.
With the witness will be willing to make it of record that indeed this notice of death was given to and submitted as part of the record.
If you allow me, I'm on direct still, Your Honor.
No, but we are trying to
I'll
expedite
ask
the
her the
proceedings.
question. I'll ask her the question. Yeah, with
Counsel, respect this court, no?
with the permission of the Honorable Court, Your Honor, I want to establish the veracity of the proposition made by
right.
the prosecution. Madam Witness, can you please tell us whether or not there is anything in the records that attests to the death or establishes the time of or date of death of the defendant Jose M. Basa?
Wala po.
I'm sorry, I cannot stipulate
Wala pong
that.
notice of death. In which case, if there are no further questions on direct, may we be allowed to go directly to cross?
On what, Your Honor?
Because the witness is supposed to be here to testify on pertinent records pertaining to this case. And while we did admit the existence of several documents which transpired during the proceedings in this case, there are also several details which are indirect matters which have an importance in the
Perhaps
proceedings.
you can, if I may, Your Honor, perhaps counsel would be kind enough to request for a stipulation likewise.
Okay. May we request, may we,
You cannot stipulate, proceed to direct the questions to the witness.
thank you, Your Honor.
Would you like to stipulate?
You are directed to
Very well, Your Honor.
proceed with your direct examination.
Thank you, Your Honor. With the permission of the Honorable Court. Madam Witness, can you please state for the record your personal circumstances?
I am Lucita,
Name and personal circumstances, I'm sorry.
I am Lucita Masangkay Christie of Legal Aids Filipino, married and a resident of Valenzuela City. I am the branch clerk of court of Branch 216, Regional Trial Court, Branch 216, Quezon City.
How long have you been the clerk of court of the Branch 216, Madam Witness?
Since October 1999, sir.
All right. Now, during your time as the clerk of court, are you still the current clerk of court?
Yes, sir.
As clerk of court, Madam Witness, can you tell us whether or not you are familiar with criminal case numbers Q9668 147 and Q9668148?
I am familiar, sir.
All right, can you please tell us what is the title of these cases?
This is People of the Philippines. Actually, there are two cases.
Yes.
People of the Philippines versus Jose Maria Basa, Raimunda Basa, Felix Carlos Becentilio, Virgilio Macabenta, Cecilia Basa, Betsy Basa, and can I look at my records? sir?
Your Honor, may we request that the
Your
witness
Honor.
be allowed to refer to the records?
Granted.
And Flor Maria Basa, Flor Maria Guidote Basa.
Now, Madam Witness, can you please tell the Honorable Court what was the charge or the nature of the criminal cases? If I recall correctly, this should appear on the face of the pleadings.
Your Honor, please, we already admitted that this is a libel case.
All
So
right.
there is no need for
The
the
court has...
question.
Your Honor, may I proceed? Thank you. Please, go ahead.
The cases were for libel.
All right. Can you please tell us whether or not and when, if any, a decision was rendered in these cases?
A decision was rendered on September 5, 2001, sir.
How many decisions were rendered? Because you told me earlier there were two cases.
Only one decision, sir, because the two cases were consolidated.
Does that mean that they were heard jointly?
Yes, sir.
All right. Now, what was the decision of the... Do you have a copy of that decision with you?
Yes, sir.
Your Honor, the decision has been previously marked. Right?
Your Honor, please, we would like to manifest that the defense has already caused the marking of the same exhibit, and this is Exhibit 176 for the defense.
All right. Noted.
All right. Can you tell us, Madam Witness, what does the dispositive portion of the decision state? Can you please attest to the outcome of the decision?
We have already admitted, Your Honor, on the same, that there was a conviction.
Your Honor, I'm a little perplexed. I thought that there had been no admissions, precisely why I have been
Your Honor,
directed to
please.
proceed.
We have made several stipulations already on the matters. Now, perhaps counsel here would be able to propound questions on those matters which we have not stipulated upon.
I said disregard the stipulation. Let it be...
We will submit, Your Honor.
Direct the questions and subject to the objections of the prosecution.
Thank you, Your Honor. May I just therefore request that the clerk of court, who is here to certify the decision and to attest to its authenticity anyway, read the dispositive portion for the benefit of the record and all concerned.
Proceed. The witness may read the dispositive portion of the decision.
Wherefore, in criminal case number Q-96-68147, the court finds accused Jose Maria Basa III, Raimunda Gorospe Basa, and Virgilio Macabenta guilty beyond reasonable doubt of the crime charged in the information for libel, and the court sentences them to suffer the penalty of 4 months and 21 days as minimum to 1 year, 8 months, and 21 days as maximum, ordering them to pay jointly and solidarily Cristina Basa Rocco Corona the sum of 200,000 pesos moral damages and 50,000 pesos for attorney's fees. Accused Cecilia Henson Basa, Betsy Basa Ten Chavez, and Flor Maria Guidote Basa are hereby acquitted. In criminal case number Q-96-68148, the court finds accused Jose Maria Basa III, Raimunda Gorospe Basa, and Virgilio Macabenta guilty beyond reasonable doubt of the crime charged in the information for libel, and the court sentences them to suffer the penalty of 4 months and 21 days as minimum to 1 year, 8 months, and 21 days as maximum, ordering them to pay jointly and solidarily Cristina Basa Rocco Corona the sum of 200,000 pesos for moral damages and 50,000 pesos for attorney's fees. Accused Cecilia Henson Basa, Betsy Basaten Chavez, and Flor Maria Guidote Basa are hereby acquitted. Let warrant of arrest issue for the apprehension of accused Felix Carlos Vicentilio. So ordered. Quezon City, Metro Manila, September 5, 2001.
Thank you, Madam Witness. Your Honor, I would like to manifest that the decisions in both cases, the dispositive portions for both dockets are virtually identical, and that the total civil indemnity of 500,000 pesos was part of the judgment. Now, you mentioned
Wait a minute.
Yes, Your Honor.
I only heard 200,000 plus 20,000 and 200,000 plus 50,000. Why 500?
Your Honor, maybe ask the witness to clarify.
Your Honor, in the first case, 200,000 pesos as moral damages,
Yes.
plus 50,000 pesos as attorney's fees.
I thought you said 20,000.
200,000, Your Honor.
No, the attorney's fees, 50,000.
50,000, sir.
In the
Your
first
Honor.
case.
Yes, sir.
And that's also true in the second case.
Yes, Your
All right,
Honor.
I stand corrected. So that's 500,000. Proceed.
Thank you, Your Honor. Now, you mentioned that the decision includes an order for the issuance of a warrant of arrest. Is that correct?
Yes, sir.
All right. Now, can you please tell us, if anything appears on the record, what did the defendants who were convicted do after the judgment was rendered by the court? The decision was rendered by the court. What did the defendants do? The accused.
Actually, sir, they did not appear in the promulgation of judgment.
All right. What else did they do? Was there anything else they did?
They filed a motion for reconsideration.
They filed a motion for reconsideration, and if I recall correctly, that was dated September 2, 2002. Am I correct?
No, sir.
When was it filed? What was the date of the motion for reconsideration?
October 9, 2001, but filed before our court on October 18, 2001.
Filed what? The date was filed on October?
The motion was dated October 9, 2001, but the office or the court received the said motion on October 18, 2001.
Thank you. Now, can you tell us, what did the court do with these motions for one motion for reconsideration or two?
One motion, sir.
What did the court do with this motion for reconsideration?
The motion for reconsideration was set for hearing.
What else? What was the resolution of the court
Ah.
on the motions for reconsideration?
The motion for reconsideration was denied.
When was this denied?
On September 2, 2002, sir.
Do you have proof of the denial?
The order, sir.
Is there an order to
Yes,
that
sir.
effect? Can you please produce the order, Madam Witness? Na-mark na ba ito?
Just a minute, counsel. What's the relevance of this with respect to the impeachment?
Your Honor, as I was pointing out earlier, this will result in the acquisition of the shares of the Basa Guidote Corporation because of the civil indemnity. There is a levy on execution, but before that, I have to establish the finality of the judgment, Your Honor. Afterwards, we will show you that the shares of the corporation have been acquired by an individual.
Acquired by Mrs. Corona.
No, Your Honor, by someone else. And that has a direct bearing on the...
All right, proceed.
Thank you, Your Honor.
Proceed.
So, you told me that it was resolved by order of the court on what date, Madam Witness?
On September 2, 2002, sir.
All right. And what was the resolution of the court on the order?
The dispositive portion, sir.
Yes, I think so.
Wherefore, finding no cogent reason to disturb or modify the decision dated September 5, 2001, the instant motion for reconsideration is denied.
Your Honor, may we request that the order denying the motion for reconsideration dated September 2, 2002 be marked as Defense Exhibit 249.
Mark it according.
Your Honor, please, may the prosecution be allowed to likewise adopt the same as Exhibit 11O.
Granted.
Correction, 11P, Your Honor.
P? Is that 11P?
All right, granted with that correction.
Can you tell us, Madam Witness, what is the status of that order denying the motion for reconsideration?
Sir, status
Yes, what is the status?
of the order denying the motion.
Yes, of the
for-
denial. What happened after the denial?
The prosecution filed a motion for issuance of a writ of execution. Sir,
What, did the accused filed anything?
no, sir.
Did the accused oppose?
No, sir.
Did the accused file another an appeal or anything of the sort?
There was no appeal, sir.
No appeal. In other words, what is the status now of the denial of the motion for reconsideration?
It is already final.
Final as of when?
As 15 days from receipt.
And according to your records, what date is that, Madam Witness?
October 12.
What is the date of that of the receipt by the accused, Madam Witness?
The council received the order of denial, sir, on September 26, 2003.
Your Honor, may we make of record that the witness is showing me what appear to be registry receipt return cards, which indicate that they were received on September 26, 2002, and I invite the opposing counsel to peruse them. Okay? September 27, one day apart?
Hindi po ito po
Nine,
yung date ng
date
order.
order.
Ito po stop na.
Yeah, your stamp po.
September 27. Saan po?
Oh, this was received by counsel, Madam Witness, am I correct?
Yes, sir.
All right. Your Honor, may we request that the cards which appear to be receipts, registry receipts, acknowledging receipt of the order denying the motion for reconsideration be marked as Defense Exhibit 250.
We manifest
Mark
that
it accordingly.
we join, we confirm.
But, counsel,
I'm sorry, Your Honor, I stand corrected. These have been previously marked as 177-A. To be marked today as 177-A.
right, mark it accordingly, but back to the point.
Yes, Your Honor.
This decision against Josebasa et al. Became final and executory.
Yes, Your
All
Honor.
right. Was it executed?
The next question is precisely that.
You're too verbose. Go direct to the point.
Was a writ of execution issued by the court?
Yes, sir.
When?
On April 24, 2003. Sir.
All right. No further questions on the direct, Your Honor. We just have to mark the writ of execution.
Executed against what?
I'm sorry, Your Honor.
That decision was executed for against what?
Against the defendants, Your Honor, who were convicted.
Yes, and what was the effect of the
that,
execution?
that will be testified to by the sheriff, Your Honor, who is the next witness.
All right.
Your Honor, please, we would like to manifest...
Ross,
No, the defense already had this document marked as Exhibit 178. The writ of execution as 178. May we be allowed to have the same mark for the prosecution as Exhibit 11Q?
mark it accordingly for the prosecution.
No further questions on direct, Your Honor.
Cross, Your Honor.
Any cross?
Yes, Your Honor.
Yes, proceed.
Now, Madam Witness, sinabi niyo kanina na kayo ay nag-umpisa bilang branch clerk of court noong 1999 hanggang sa ngayon. Tama po ba?
Opo.
Therefore, alam niyo po, bilang tiga-ingat ng lahat ng dokumento sa hukumang ito, sa hukumang branch 216, meron po kayong kaalaman or nasa kustodiyan niyo ito. Opo. Pagkatapos na mag-file ng motion for reconsideration, tama po ba na bago maibigay o bago mabigay ng korte ang writ of execution, nagkaroon po dito ng notice of withdrawal ang counsel ng akusado na si Jose Maria Basa at merong pleading na sinubmit sa court. Tama po ba?
May nabasa po ako based on records.
Pwede niyo po bang tignan sa inyong mga records exactly kung nasaan po ang dokumentong ito? Your Honor, please, just to help the witness, we have a copy of the motion to withdraw filed by the counsel for the accused. Maybe we're allowed to show the same.
Yes, proceed. Who was the counsel for the accused?
In this particular case, Your Honor, the counsel for the accused is
Was.
the law office of Fortune Narvasa in Salazar. This is dated December 20, 2002. Do you confirm this, Madam Witness?
Yes, ma'am.
Now, this is a certified true Xerox copy. Meron po ditong nakalagay sa ilalim, certified true Xerox copy, Attorney Lucita D. Masangkay Christie. Kilala niyo po kung sino ito?
Po yan, ma'am.
So, pinatotohanan niyo po itong motion to withdraw.
Yes, ma'am.
May we ask, Your Honor, please, that this document be marked as Exhibit 11R for the prosecution.
Mark it accordingly. Was that withdrawal prior to the judgment?
This was prior to the to the submission of a motion for issuance of the writ of execution, Your Honor.
All right.
Now, Madam Witness, maaari niyo po bang tignan ang lahat ng mga dokumentong kalakip dito sa motion to withdraw na ito? Tama po ba na sa kahuli-huli ang pahina ng motion nito ay merong isang sulat na may petsa ng November 26, 2002 at ang pumirma dito ay isang Ana Basa? Kinukumpirma niyo po ba ito?
Opo.
Now, ito po, dito po sa dokumentong ito, sinabi po ni Attorney Fortune na siya po ay hindi na ang maging abogado na
Your Honor.
akusado.
With all due respect.
Let the lawyer finish first.
Thank you, Your Honor.
Can you read, Madam Witness, maaari po bang basahin ninyo ang unang talata ng sulat na inattach para kay Attorney Raymond Fortune?
One of the things that we had to go through after Dad's passing, aside from the emotional vacuum that he left, was to make decisions on matters and concerns that he left unfinished.
Sa inyo pong pagkakaintindi, Madam Witness, ano po ang ibig sabihin ng
Your
Dad's
Honor.
passing?
Speculative and
Your Honor, this is record of the
Right.
case. Ano po ang pagkakaintindi niyo po dito sa talatang ito na lalo na sinabi niya na Dad's passing? Ano po ang inyong pagkakaintindi doon?
Na ang kanya pong ama ay namatay na.
So therefore, nung November 26, 2002, as of that date, namatay na po si Jose Maria Basa.
Opo.
Ayon kay Ana Basa na anak ng akusadong si Jose Maria Basa.
Yes, ma'am.
At, Your Honor, please may we ask that this particular paragraph be marked as Exhibit 11R-1. Ito. Sabi niyo po, Madam Witness, na kayo po ay, alam niyo na ito ay isang libel case? Alam niyo po ba kung sino-sino ang mga partido sa kasong ito?
Alam ko po.
Alam niyo po kung ano po ang kanilang relasyon sa isa't isa?
Nabasa ko po sa records.
Ang private complainant po sa kasong ito ay si Cristina Corona.
Opo.
Alam niyo po ba kung ano ang kanyang relasyon sa namatay ng Jose Maria Basa?
Nabasa ko po na uncle.
Uncle niya.
Kanya po.
Okay. Dito po, nakita natin na si Attorney Fortun dinikit ang letter ni Ana Basa kung saan sinabi niya na namatay. Ang private complainant po ba dito na si Mrs. Cristina Corona, sinabi po ba niya na ang kanyang uncle o tiyo ay namatay?
Wala po akong nabasang ganun.
Sapagkat sa ibang kaso, marami po kasing kaso ang mga basa. At sa isang kaso, meron pong sinabmit si Mrs. Cristina Corona na kung saan sinabi niya na si Jose Maria Basa ay namatay noong August
Objection, Your Honor.
2002.
This is not part of the records
No,
that the witness...
allow the witness to answer.
All right.
August 2002.
Counsel,
I would like...
Counsel, I warn you once more. Do not interrupt the counsel while asking the question.
Yes, Your
It's
Honor.
improper,
I would apologize.
Your Honor.
unethical.
I apologize, Your Honor.
Ako pala yun. Okay. Now, I'm showing to you, Madam Witness, isang manifestation na kung saan ang petitioners ay si Asuncion Basa Rocco at si Cristina Rocco Corona. At ito ay may date. Ito ay binigay sa ibang korte. At dito, sa paragraph 1 dito, maaari po bang basahin ninyo?
It has come to the knowledge of petitioners that Oppositor Jose Maria Basa III passed away in Carson City, Nevada, United States of America in August 2002.
Now, kasama po dyan kasi sa mga dokumento na yan ay isang death certificate ni Jose Maria Basa sa Carson City. By the way, ang dokumento pong yan ay may petsang 11 October 2002. Okay? Now, Your Honor, please, may we request that this manifestation and motion be provisionally marked for the prosecution as Exhibit 11-S. And the first paragraph
Granted.
as 11S-A, dash 1. It consists of 5 pages.
Your Honor, may we request that the document be similarly marked for the defense as exhibit, 250, Your Honor.
Granted.
Now, Madam Witness, klaro dito na hindi lang sinabi ng abogado ng akusado na siya ay nag-withdraw. Sinabi niya rito na base sa impormasyon ng kanyang anak, namatay ang kanyang ama. Pagkatapos nun, just a few days after that, si Mrs. Corona mismo nag-notify sa ibang kaso na ang kanyang tiyo ay namatay sometime in August 2002. Tama po?
Tama po.
Objection, Your Honor.
What is the ground of the objection?
The objection, Your Honor, is it's immaterial. It has nothing to do with the competency of the witness.
Your
Who is
Honor.
the branch clerk in
Let
Quezon
the
City?
witness answer.
Already answered, Your Honor, please. That there was actual notice given not only by the accused and counsel, but also by the private complainant herself, Mrs. Cristina Rocco Corona.
The actual death
The actual death of the accused, Jose Maria Basa,
happened when?
on August 29, 2002, Your Honor, in Carson City, Nevada.
Okay.
Now, Mr. Witness, Madam Witness, I'm sorry, sinabi niyo na nagkaroon ng writ of execution.
Yes, ma'am.
Now, nagtataka lang po ako. Kasi kung may notice na po ang korte, at mismong ang private complainant dito na si Mrs. Cristina Corona, ay alam na ang akusado mismo ay patay na. Paano ho magkakaroon ng iba pang proseso laban sa akusadong si Jose Maria Basa?
Objection, Your Honor. The question is misleading. Because
Let the witness answer.
Pwede pong pakiulit ang tanong.
Ibalik lang natin, Madam Witness, para mas klaro. Yung motion for reconsideration natin, ang petsa ay, ang motion for reconsideration natin
Ang motion for reconsideration.
ay October 9, 2001. Okay. Ang order granting the writ of execution based on the motion for issuance of writ is April 24, 2003. In the middle of all these things, sa gitna ng mga pangyayaring to, at bago nagkaroon ng issuance ng writ of execution, nagkaroon ng notice of death, dispersed, ang akusado dito mismo ay patay na. And under the revised penal code, once there is, once the death of the accused happens, then both the criminal as well as civil liability is extinguished. Tama po ba?
Tama po.
Then, kung ang notice of death ay ibinigay na sa korte, paano po nangyari na nagkaroon pa ng writ of execution? Di po ba dapat, under the rules of court, ang dapat na po mangyari, ang private prosecution, for example, dapat na mag-submit ng separate action para sa civil indemnity na 500,000 piso. Nangyari po ba yon sa kasong ito? Nagkaroon ba ng filing ng separate case dahil sa pagkamatay ni Jose Maria Basa?
Wala po.
Wala. At actually, ang nangyari, na-issue ang writ of execution na noong April, under the order dated April 24, 2003. Ano? At actually, namatay si Jose Maria Basa during the pendency of the motion for reconsideration because he died actually on August 29, 2002. Yun lang po material dito. August 29, 2002, namatay si Jose Basa at alam yon ni Cristina Corona. Pero, nag-file pa rin po sila ng motion for issuance of writ of execution against the accused Jose Maria Basa and his wife Randy Basa. Kaya nagkaroon ng writ of execution dated April 28, 2003. Tama po ba?
If Your Honor, please, with the kind permission of the
Tama
court.
po.
Yes.
The question... The question, Your Honor, should have been addressed to the judge of record. He's merely a clerk of court, Your Honor.
Well, he's,
He is merely implementing... Yes, Your Honor.
he's under cross-examination. If she knows the answer.
She already answered, Mr. Justice Cuevas, and also you'd just like to point out that the witness in this case is not an ordinary witness.
That's correct,
She is
but,
a lawyer. She is the branch clerk of branch 216 Quezon City. Therefore, not only does she have custody of all the records in this case, she would also know the basic rules, not only of the penal code,
Yes,
but
Your-
also of the rules of court.
May we reply, Your Honor, with the kind permission of the court?
Well, go ahead.
That may be correct, Your Honor, but being merely a clerk of court, he has no power nor any authority to prevent the judge from acting one way or another, either denying or granting it. There is a decision in this case. There was a motion for reconsideration. It was denied, and therefore the decision became final. This is not-
You're questioning the competence of the witness?
Insofar as the issue of why the execution continued, Your Honor, because that is not within her control.
But this
Your
is your own witness, Mr. Justice.
Yes.
The question is only asking for facts.
No, that's not,
Whether there was a writ of execution issued after death. That's a factual issue.
no, that is not the question, Your Honor. The question, with due respect, Your Honor.
What was the question?
The question was, why was there a writ of execution issued even after the death of the accused, Your Honor? Because apparently they are of the theory that the moment the accused died, the case is...
Let the witness answer if she knows.
Already answered.
Ano, sir?
What was the answer?
She answered yes. That,
Yes? Yes,
tama
what?
po na in-issue ang writ of
After the
execution.
death. Oh,
After the death.
oh.
Now, one final point, just to make things very clear.
Oh.
Madam Witness, you said a while ago that the motion for reconsideration was denied. And this
Yes, ma'am.
is in the order of the court dated September 2, 2002. Tama
Admitted,
po?
admitted, Your Honor.
Admitted. Now, kanina sinabi niyo rin na nagbigay ako sa inyo ng mga dokumento na nagsabi na August, si Ana Basa sinabi yung tatay niya namatay. At sinabi rin mismo to ni Cristina Corona na ang uncle niya ay namatay. These dates, This date is on August 29, 2002. I think the last question I will pose on you is very, very simple. Does the date of August 29, 2002 come before the date of September 2, 2002, which is the date when the order of the motion for reconsideration was resolved?
It's a matter of judicial note. If Your Honor, please, that's a
This
matter
is a
of
very
judicial
simple
notice.
question.
Let the witness answer.
Yes, ma'am.
Then we have no further questions for this witness, Your Honor.
Oh, recross.
No redirect, Your Honor.
Redirect. Okay. The witness. Are there no more questions?
No redirect, Your Honor.
All right, the witness is discharged.
Thank you, Your Honor.
Next witness.
We call our next witness to the stand, Your Honor, Mr. Joseph Bisnar, Sheriff of Branch 216 of the RTC of Quezon City. Mr. President, may I request for 1 minute to fetch the witness?
Granted.
Thank you.
Granted.
Thank you, Your Honor.
Your Honor, again, I would like to present Mr. Bisnar in order to establish the execution of the decision testified to by the previous witness. And again, I would like to, in the course of stating the purpose for which we are offering his testimony, invite the prosecution to admit the same if they are so inclined. The testimony of this witness is being offered for the purpose of establishing that a writ of execution was issued in criminal cases Q96-68147 and Q96-68148 by the Regional Trial Court of Quezon City, Branch 216.
What's the pleasure of the prosecution?
We admit, Your Honor, but subject to cross-examination on the implementation of the writ of execution.
All right.
Secondly, his testimony is offered to establish that he was the one who executed the writ of execution in these said cases.
We admit, Your Honor.
Third, that the execution did in fact take place on September 30, 2003.
We admit, Your Honor.
All right.
And that in fact in the course of the execution, a total of 4,729 shares of the Basa Gedote Enterprises.
How much?
4,729, Your Honor.
729
29 shares of the Basa Gedote Corporation Enterprises Incorporated were sold for the amount of 25,000 pesos.
sold for the price of 25,000 pesos.
At public auction, Your Honor.
Yeah.
Yes.
What is the total capitalization of the corporation?
Your Honor, if I'm not mistaken, the authorized capital stock is 10,000 shares with...
all issued and outstanding?
No, Your Honor. Only about 5,325 were issued. 5325.
Who are the stockholders of the corporation?
They are all members of the Basa
Will you
Guidote.
kindly, if you know, state them into the record?
I do not have the list with me right now, Your Honor, but may I be allowed to submit them through a manifestation?
Yes.
Thank you, Your Honor. Your Honor, the second...
Who are the registered owners of these 4,729 shares against which the writ of execution was levied?
Your Honor, the 4,729 shares belong to the defendant Jose Basa.
All of it?
Yes. Yes, Your Honor. And in addition, another 110 shares were also executed against the co-accused or co-defendant Raimundo Basa.
So, out of
5,325.
the balance is 6,
4839, Your Honor.
4,736.
4839, Your Honor. 110 shares to Raimundo Basa. And so 4,839 shares were auctioned off for a total amount of 28,000 pesos.
If you subtract 4,729 shares from 5,325, what is the balance?
486, Your Honor.
486. And who are the owners of this 486?
They would, I think, Sister Flory Basa would be one of them, though I'm not certain as to
All
the
right.
remainder.
And proceed.
And that these 4,729 shares and the 110 shares that were auctioned off by Sheriff Bisnar,
4,729
729
plus
and 110
110.
belonging to Raimundo Basa, Mr. President.
Was he a respondent in the case?
Yes, he was convicted as well, Mr. President. And that that sum of shares was sold at public auction for 28,000 pesos to one Carla Corona Castillo, the daughter of the Chief Justice.
We admit, Your Honor.
All right.
In that case, Your Honor, I can dispense with the direct.
And this is the owner of the property
At
that,
this,
that was sold to
to the city of Manila,
to
Your
the
Honor.
city of Manila
Yes, Your Honor.
for 34.7
0.7 million.
million.
Yes.
That was the asset of the corporation.
Yes, Your Honor. And the purpose for establishing these facts is to demonstrate to the court that whatever it is was done with the so-called Basa Guidote funds will in effect be capable of ratification by the purchaser of these shares
Yeah.
as virtually the sole stockholder.
And when was the sale to the city of Manila?
That was in 2001, if I'm not mistaken.
2001. And the acquisition of the shares by Carla Corona?
2003, Your Honor, September 30.
And the shares were only sold for 25,000 pesos?
28,000 pesos in all, Your Honor. In public auction, Your Honor.
For a property, for a corporation that has an asset of 34.
That is right, Your Honor.
All right. Go ahead.
So I want to know if the opposing counsel is willing to stipulate.
We stipulated already on the fact of the sale, Your Honor, on the fact of the issuance of the certificate of sale in favor of Carla Castillo, Your Honor. Subject to cross, Your Honor.
All right. We also, Your Honor, then
By the way,
yes,
just
Your Honor.
for the information of this court, this is a peripheral issue, but nonetheless, since you connect it with the impeachment case, what was the percentage of this 4,839 to the totality of the shares of stock of the corporation?
Your Honor, mathematically that amounts to 90.87%.
90.87%.
Yes, Your Honor.
3% was the minority.
Yes, Your Honor.
Did the minority got paid for their shares?
Not yet, Your Honor. The remaining, the remaining shares of 485 or 486 have not been acquired by either the Chief Justice or his daughter. They remain in the hands of the, if I'm not mistaken, some of the siblings of Mrs.
Is the corporation liquidated?
No, Your Honor, it has not
Not
been
yet.
liquidated.
Is the board of directors constituted?
No, Your Honor. It is not an operational
When
corporation.
the property of the corporation was sold to the city of Manila, was there a stockholders meeting to authorize the sale of all or substantially all of the
Yes,
assets?
Your Honor, there was a valid and legitimate board authorization issued by the board of directors previously, by the stockholders previously.
Was there an actual transfer of the shares of stock to the buyer?
Your Honor, there appears to be a problem with respect to the certificate of sale is construed as the transfer of the shares of stock. The registration of the sale, Your Honor, has not been completed because up to this time, the stock and transfer book has neither been located nor reconstituted.
Then who voted, who are the stockholders who voted to authorize the sale of all or substantially all of the shares of the corporation?
Your Honor, the sale of the shares was by virtue of public auction.
No, I'm talking about the sale
The
of
property?
the land.
The property, Your Honor, had been previously authorized even before the corporation ceased operations. A power of attorney was issued in favor of Cristina Corona
By whom?
by the stockholders and the persons in control of the corporation, Your Honor.
The
For the record, Mr. President,
gentleman from Illinois.
yes, I think we can refer to the records. The authority of Cristina Corona was issued by the board of directors, not by the stockholders. It is the board of directors, a 14-year-old authorization by the board of directors, not the stockholders, Mr. President. Just for the record.
That is right, Your Honor.
So it is not the stockholders' consent.
Anyway, you are all great corporation lawyers. You better study this angle.
Well, Your Honor, that is correct. The board of directors who issued that authorization were also the stockholders of the corporation.
No,
At any rate, it was not a stockholders meeting.
Even then.
Anyway, that is the point of the witness, Your Honor, to establish that the bulk of the shares of the Basa Guidotti Corporation are now owned by Carla Corona Castillo, the daughter of the Chief Justice. And if
And so the money went to the proceeds of the sale of the property of Basa Guidotti, 34.7 million went to Carla Corona.
that is not quite how it happened, Your Honor.
Why not? If she's the owner of the corporation.
As in fact, we will establish later on, this was entrusted to its current custodians.
For what?
It is a matter between family members, Your Honor, and we will show that she entrusted the management of the funds.
Well, anyway, we will come to that, but I will tell you, my understanding of corporation law is all the proceeds of the corporation property, if sold, will go to the stockholders,
That is right.
not to anyone else.
That is right,
All right,
Mr.
proceed.
President.
We'll proceed with our cross, Your Honor.
Your Honor, just a few questions with the sheriff, if you don't mind. Mr. Witness, good afternoon. Yes, please speak into the microphone. Yes. Now, you are the one who executed the writ of execution, am I correct?
Opo.
Can you please, pwede nyo bang sabihin sa amin, ano po ang ginagawa nyo pag pinapatupad nyo po yung writ, nung pinatupad nyo po itong writ of execution na pinag-uusapan po rito?
Ang una po ay nagpa-receive po ako ng kopya ng writ of execution. Sa case po nito, sinabay ko na po ang pag-serve ng writ of execution saka notice of garnishment po.
Meron pa po ba kayong ibang ginagawa sa pagpapatupad po ng itong mga writ of execution?
Opo, pag natanggap na po yung writ of execution saka yung notice of garnishment at meron pong yung
Pari lang, pakisalaysay lahat ng paraan kung paano nyo po inaanunsyo yung auction sale. Although alam naman natin yan paano nyo ba ginagawa yun?
pag na-receive na po yung notice of sheriff sale, isi-set mo ang sale for auction. In this case po, sinet po ng September 30.
O nga, paano nyo po inanunsyo sa publiko?
Sa publiko po, sa takdang oras po, tinatanong ko kung merong
Hindi ba, sandali lang, hindi ba mayroong publication yan sa periodiko?
In this case po, wala po dahil
Bakit?
posting lang po ito.
Ha?
Ang publication po ata sa real property.
Sige. Kung shares of stock, walang publication.
Pagkakalam ko po, wala na po. Posting lang po.
Sige.
Ito po ba'y ginawa nyo?
Opo.
Saan nyo po pinost itong sinasabi nyong paalala?
Sa bulletin board po ng courtroom ng branch 216.
Ito po ba'y pangkaraniwang gawain?
Opo.
Sa madaling salita, pinost nyo doon sa bulletin board at sa ang petsang nakatakda para sa auction ay ano po?
September, pwede sa records ko. September 30 po, 2003.
September 30, 2003. Noong pong araw na yon, ano pong ginawa nyo para ipatupad ito pong writ of execution matapos nyo pong i-post yung notice doon sa bulletin board?
Nung September 30 nga po, nung bandang bago ikasampu pa ng umaga, bumubaw ako sa lobby ng Hall of Justice at doon po ay tinanong ko kung mayroong mga interesadong mag-bid doon sa shares of stocks.
Meron po ba ang sumagot?
Ang sumagot po ay isang tao lamang.
Sino po? Kung natatandaan nyo?
Si Carla Castillo po.
Meron pa po bang ibang tao na dumalo doon sa auction?
Wala po. Wala po, maliban po kay Mrs. Corona.
Meron pa po bang iba?
Wala na po. Yung abogado po nila.
Yung mga abogado. So, sa makatwid po, yung naroon nung ipatupad nyo po itong auction ay si Carla Castillo,
Carla Castillo.
Mrs. Corona,
Mrs. Corona po.
at
Yung lawyer ho nila.
syempre kayo.
Opo.
Yun. Ano ho ngayon ang nangyari? Nung nandun na ho silang lahat at nagsabing sila interesado. Sino ho nagsabing interesado siya doon sa binibenta nyo mga shares of stock?
Si Carla Castillo po.
Si Carla Castillo. Ano po ang ginawa nyo nung nagsabi siya na siya interesado?
Nung sinigaw ko nga po na may interested na bidders, nung wala po ibang sumasagot,
Sinimulan ko na po yung auction sale. At pagkatapos po noon, nagbid na nga ho si Carla Castillo.
Ano po ang bid niya kung inyong natatandaan?
Ang bid po niya po, the total shares 28,000 po pesos.
Magkano po yung ipinatutupad niyo po?
Magkano?
Magkano?
28,000 pesos po.
Ano ang par value ng shares?
Ako po, hindi ko alam po.
Does council know the par value of these shares?
I'm sorry, Your Honor, I have the articles of incorporation here, but I'm not sure whether it is stated, Mr. President.
10 pesos, 100 pesos.
100 pesos each, Mr. President.
You're talking here of 4,839 shares. That means you have 483,900 pesos
Value.
worth of shares at par value.
Yes, Your Honor.
And given the value of the property at the time of the sale, which was sold at 34,700,000 pesos, the fair market value of the share is a lot more than the par value.
That appears to be the case, Your Honor. Although, may I point out that...
We'll just establish that as a fact.
Yes, Your Honor. Well, Your Honor, I'm sorry, but that is the par value. The shares were merely subscribed, I think, at that time. So,
But, nevertheless,
yes, Your Honor.
But
With
the-
respect to the property,
but the value behind those shares is at least 34.7 million pesos. Huh?
insofar as the property is concerned, Your Honor, yes. So, if I may proceed, Mr.
Go ahead.
President. So, Mr. Witness, sabi niyo po na nagbid nga po ng 28,000 pesos. Ano pong ginawa niyo?
Nung nagbid po ng 28,000 pesos, tula naman po ibang bidders na, inaward na po sa kanya yung shares of stocks na
Kanino po? Sino po siya?
Carla Castillo po.
Inaward niyo po yung shares of stock na in-auction.
Opo, baliw siya ang nanalo.
Si Mrs. Corona ba hindi nagbid?
Hindi po.
Pero siya ang inatasan na magbenta ng lupa, hindi ba?
He would not know, Mr.
So
President.
I'm asking kung alam niya.
Hindi ko po alam, Your Honor.
Hindi mo alam.
Hindi ko po alam ho.
Okay, go ahead.
Thank you, Your Honor. Magatapos pong na-award sa kanya, ano pong ginawa niyo?
Nag-issue po ako ng receipt on behalf of Mrs. Corona.
Oho.
Yun nga po, ginawa ko yung receipt ko at tapos pinirmahan ko ni Mrs. Corona.
Ano ho ba, maaari nyo bang ipaliwanag sa amin, ano ho bang ibig sabihin ng receipt na in-issue nyo?
Look, may I just... ang bumili ng shares of stock, anak ni Mrs. Corona.
Opo.
Ang
Carla Castillo po.
tumanggap ng pera doon sa anak na bumili ng shares of stock, ang nanay si Mrs. Corona. Di ba?
Opo.
Sang-ayon sa mga dokumento na nandito na sa impeachment court, Mrs. Corona ay ahente ng korporasyon upang ipagbili yung lupa. Sa makatwid, alam niya ang presyo ng lupa na ipinagbibili niya. Alright, go proceed.
Thank you, Your Honor. So nag-issue po kayo ng receipt mula kay Mrs. Corona, katibayan ng pagbayad po ng shares. Tama po ba?
Opo.
Tapos, meron pa po ba kayong ginawa? Ano pa ang dokumento ang in-issue nyo sa kanila?
Pagkatapos po nang gumawa po ako ng certificate of sale.
Na nagsasabing, ano pong nilalaman ng iyong certificate of sale? Kung naaalala nyo.
Nandito po.
Submit the certificate of sale. That will be the best evidence.
Your Honor, actually it has been marked. But may I request that the receipt that was mentioned earlier by the sheriff be adopted as defense exhibit number 251.
I don't think there's any question about the payment of that consideration for the bid.
Just for the record, Your
Is
Honor.
there any? Are you questioning that Carla Corona paid that X amount for the 4,839 shares with a par value of 100 pesos each?
No, Your Honor.
Yeah. No,
Very well, Your Honor.
No question.
In which case, I'm done with my direct examination, Your Honor. Your Honor, may I request anyway that the receipt nonetheless be marked? Anyway, there appears to be no objection from the prosecution.
Mark it accordingly.
Thank you, Your Honor. 25. With that, Your Honor, I have no further questions.
Ross.
Yes, Your Honor. Magandang hapon po, Sheriff Bisnar.
Magandang hapon po.
Sabi po nyo, kayo ay sheriff ng Regional Trial Court of Quezon City, Branch 216.
Opo.
Ilang taon na po kayong sheriff ng nasabing korte?
Mula po ng 1994.
1994. So masasabi po natin na kayo ay nasa mga 16 years ng sheriff sa korting ito, di po ba?
Pwede na po, oo.
Salamat po. Maaari rin natin pong sabihin at kayo ay sasang-ayon sa akin na sa loob ng 16 years na pagiging sheriff po ninyo, kayo ay bihasa at alam na ninyo ang mga alituntunin at patakaran ng pagpapa-implement ng writ of execution, hindi po ba?
Hindi naman hubi isang mesa, pero marunong na po siguro.
Ito pong pinag-uusapan natin ay ang Rule 39 ng Rules of Court, di po ba?
Opo.
Ito pong writ of execution, mayroon po ba kayong kopya ng writ of execution marked as Exhibit 178 of the defendant?
Meron po.
Of the respondent. Ito pong writ of execution na pinirmahan nung judge ng korting ito, ay kayo ay inaatasan na ito ay implement, particularly ang award of civil damages sa dalawang kasong ito na ang total ay 500,000, hindi po ba?
Opo.
Now, Sheriff, tama rin po bang sabihin na, bago nyo i-implement ang writ of execution, ay kailangan ninyong i-familiarize at alamin ang mga nangyari bago ma-issue yung writ of execution sa records ng korte, hindi po ba?
Sa akin po, yung kung ano pong inaatas sa akin ng writ of execution, yun lang po ang importante.
Kanina po sa isang testigo ay inilabas ng prosecution ang isang motion to withdraw na i-final ng dating abogado ni Jose Maria Basa III at yung kalakip doon sa motion to withdraw ay ang sulat ni Ana Basa sa abogado ng Fortune Narvasan Salazar. Ipapakita ko po sa inyo, Sherry.
We admit the existence of the document, Your Honor.
Tama po bang sabihin, Sheriff, na nalaman ninyo at...
Sandali lang. Ano ang answer ng witness?
Wala pong...
Ipinapakita ko pa lang. I will ask the question now.
Okay, go ahead.
Tama po bang sabihin, Sheriff, na nalaman ninyo na ang pagkaka-file nitong motion to withdraw at ang kalakip na sulat ni Ana Basa sa korte na nagsasabi na ang kanyang tatay, isa sa mga akusado na pinagbabayad dito sa korting ito ng 500,000 piso ay patay na. Hindi po ba?
Ngayon ko pa lang po nalaman to.
Okay. Sheriff, kayo, sabi nyo kanina, kayo ay pamilyar sa alituntunin natin sa pag-i-implement ng writ of execution. Alam po ba ninyo ang Section 7, Rule 39 ng Rules of Court regarding execution in case of death of party? Ito po, babasahin ko sa inyo, particularly po yung section paragraph B. In case of death of the judgment obligor against his executor or administrator or successor in interest, if the judgment be for the recovery of real or personal property or for the enforcement of a lien thereon. Alam po ba ninyo ito?
Nabasa ka na humisan, no?
Ibig sabihin, Sheriff, na pag mayroon na kayong writ of execution at napag-alaman ninyo na ang akusado sa kasong ito ay namatay na, depende ang gagawin ninyo kung ang inuutos ng korte ay recovery of real property or personal property or for pinagbabayad siya ng sum of money. Hindi po ba?
Opo.
Hindi po ba, Sheriff, alam din ninyo na pag ang utos ng korte sa writ of execution ay pinagbabayad siya ng pera, kagaya sa korteng ito, ng 500,000, hindi po ba pagpatay na ang akusado, hindi na po pwedeng implement ang writ of execution?
Hindi sa case po, hindi ko man alam na patayin na.
Pero alam po ba ninyo na ang ipinag-uutos ng batas ng Rule 39 at ng Section 5, Rule 86 ng Rules of Court na pag ang utos, sabi ko nga sa inyo, pinagbabayad ng sum of money, ang writ of execution sa isang patay na ay hindi na dapat ginagawa. Hindi po ba? Alam po ninyo yan?
Hindi ako po masyadong familiar doon.
Akala ko po kanina, Sheriff, sabi ninyo, hindi kayo bihasa, pero sabi ninyo, marunong at nabasa ninyo naman na ang Rules of Court.
Your Honor, I think counsel is arguing with the witness. The sheriff answered he did not know.
Let the witness answer.
Hindi ko nga ho alam yung tungkol sa rule na yun na...
Hindi po ninyo alam. Wala pa pong pagkakataon na kayo ay na-issuehan ng writ of execution na ang isang party ay patay na.
Pagkakatanda ko po, wala po.
So ito ang unang pagkakataon ngayong nalaman nyo na si Jose Maria Basa III ay patay na bago ma-issue yung writ of execution. Ito ang unang pagkakataon.
O ngayon ko pala po nalaman.
Okay. Ngayon, itong rules of court po natin ay mayroon ding specific na section kung papaano natin i-implement ang isang tinatawag na judgment for money. At ito ay nakalagay sa section 9, di po ba?
Opo.
Bago po tayo pumunta dyan, hindi po ba, Sheriff, kayo po ay nag-issue ng Sheriff's Report sa mga ginawa po ninyo?
Opo.
At ito po ay dated March 16, 2012?
Opo.
Kailan nga po ba ninyo ginawa yung auction sale dito?
2003 po.
2003 at kayo ay nagbigay ng Sheriff's Report 2012. Ilang taon po ang nakaraan bago kayo nakagawa ng Sheriff's Report?
Siyam po.
Ipapakita ko po sa inyo ang Sheriff's Report certified through Xerox copy ni Attorney Lucita D. Masangkay Cristi.
Your Honor, we admit the sheriff's report. We admit the date as well.
Okay. We request that it be marked as our exhibit 11C. 11T, Your Honor.
Granted.
May we likewise adopt the exhibit as Defense Exhibit 252, Your Honor.
Granted.
Sheriff, hindi po ba nakalagay dito sa ating rules of court? Ito po kasi ang ating, kumbaga, tawagin nating Biblia natin, mga abogado at mga sheriff. Hindi po ba nakalagay po dito sa Sheriff's Report, sa rules of court natin? At babasahin ko po para sa inyong benefit. Section 14, Return of Writ of Execution. The writ of execution shall be returnable to the court issuing it immediately after the judgment has been satisfied in part or in full. Hindi po ba ang itinatakda at ang inuutos sa inyo ng rules of court natin sa binasa ko ay immediately, whether partial or full, ang satisfaction?
Opo.
Ang 9 na taon po ba ay immediate, Sheriff?
Kung pwede po ako magpaliwanag,
May katungkulan po yan ng abogado ng depensa para kayo ay magpaliwanag. Salamat po, Sheriff.
Yes, sir.
Now, Sheriff, hindi po ba dito sa ating rules of court, pag mayroon kayong mga hindi ginawa na hindi ayon sa ating rules of court, kayo ay pwedeng makasuhan o mapagbayad. Ito po ay babasahin ko. Tatanungin ko lang po sa inyo kung alam nyo ito. Ito po ay ang section 17, penalty for selling without notice or removing or defacing notice. An officer selling without the notice prescribed by section 15 of this rule shall be liable to pay punitive damages in the amount of 5,000 pesos to any person injured thereby, in addition to his actual damages, both to be recovered by motion in the same action. Ngayon, Sheriff, in connection dito sa binasa ko, sabi ninyo sa pamamagitan at sa pagsagot sa tanong ng abogado ng depensa, kayo ay nag-posting.
Opo.
Sheriff, hindi po ba tama na sabihin natin ng lahat ng ating mga ginawa sa execution, di po dapat yan ay nakalagay sa ating sheriff's report?
Opo.
Dapat lahat, anumang detalye, dahil ito ay tinatakda ng ating revised rules of court, at ito ay napaka-importante dahil ang sinasabi ng mga desisyon ay dapat mandatorily complied all requirements of execution in order that the said execution and subsequent sale shall be valid. Hindi po ba dapat nandiyan lahat sa inyong sheriff's report? Hindi po ba?
Dapat po siguro po.
Pakibasa nga po ninyo, 2 pahina ninyo na sheriff's report. Pakibasa po ninyo, tingnan po ninyo ang sheriff's report. Nandyan po, ibinigay ko sa inyo. Yung certified true copy.
Sheriff's report po.
Opo.
Meron po akong kopya.
Hindi po ba, Sheriff, basahin po ninyong maigi, line by line, wala kayong sinasabi dyan sa Sheriff's report na kayo ay nag-posting ng notice of sheriff sale ng mga nasabing shares of stocks?
Hindi ko kaya ilagay.
Salamat po. So pinapaalahanan ko po kayo na kayo ay pwedeng maging liable ng punitive damages ng 5,000 and actual damages sa ginawa po ninyong pagbebenta na walang notice.
At this juncture, Your Honor, with the kind permission of the Honorable Court, may we be referred most specifically with the section involved? We are trying to locate that any and all things that took place must be recorded in the sheriff's report. We accidentally enough, we had been teaching the subject.
Council may do
Ano ho bang section yun? No?
Section 17, we cited section 17 insofar as the punitive and actual damages, Your Honor. Rule 39, Your Honor. Insofar as all matters taken up in the execution should be stated in the sheriff's report. And that is...
where is with the permission of the court, where is that particular statement that the sheriff must have
the council said
17.
Rule 39, section 17.
Yes, Your Honor, we were trying to inform ourselves again of this section 17. We see nothing to that effect. That's the basis of our observation. That the sheriff must include any and all acts performed by him. For instance, the posting of the notice and everything, which must be made immediately. We do not see that in... May we be allowed to read section 17, Your Honor?
Proceed.
Penalty for selling without notice or removing or defacing notice. They are entirely a different subject matter, Your Honor. Selling without notice or removing or defacing notice. An officer selling without the notice prescribed by section 15 of the rule shall be liable to pay punitive damages in the amount of 5,000 pesos to any person injured thereby, in addition to his actual damages, both to be recovered by a motion in the same action, and a person willfully removing or defacing the notice posted, if done before the sale or before the satisfaction of the judgment, if it be satisfied before the sale, shall be liable to pay 5,000 pesos to any person injured by reason thereof, in addition to his actual damages to be recovered. So there is nothing mentioned in here that the sheriff is under legal obligation to place in the sheriff return all the proceedings and the action taken by him. That is our point of observation, Your Honor.
Your Honor.
Let the witness answer. He is under cross.
Yes, thank you, Your Honor. I'll go to another point, Your Honor. Sheriff, di ba tinanong ko kayo kanina na ang utos sa inyo ng ating ng korte ng Branch 216 ay pagbayarin si Jose Maria Basa at ang yung mga kasama niyang mga akusado na convict ng 500,000 piso. And you will agree with me na ito po ay isang judgment for money. Hindi po ba?
Opo.
At ito po ay covered ng Section 9, Rule 39 ng Rules of Court.
Admitted.
Hindi po ba, Sheriff? Natatandaan niyo po ba yan?
Section 9 po, hindi ko natandaan.
Ang paragraph A po niyan ay nakalagay dito, immediate payment on demand. Babasahin ko po para sa inyong kapakinabangan. The officer shall enforce an execution of a judgment for money by demanding from the judgment obligor the immediate payment of the lawful amount stated in the writ of execution and all lawful fees. Sheriff, hindi po ba sinabi nyo kanina sa pagtatanong ng abogado ng depensa na ang ginawa po ninyo ay isinerve po ninyo yung writ of execution noong tama po bang sabihin na nung araw din ninyon ay isinerve nyo ang notice of garnishment?
Opo.
So, hindi po ninyo, magsasang-ayon po ba kayo sa akin na hindi nyo po tinupad ang sinasabi ng paragraph A ng Section 9 na kailangan muna ay kayo ay mag-demand na bayaran nung kung sino man akusado ang nakalagay sa writ of execution. Wala po kayong ginawa na ganoon. Hindi po ba, Sheriff?
Wala po kasi wala ho doon yung akusado.
Wala nga po dahil patay na siya, di ba?
Hindi ko alam.
Hindi nyo
At that
alam.
time, hindi ko alam. Ang kondo na yung caretaker nila.
Okay. Now, in fact, Sheriff, sa korte, nakalagay naman doon kung ano ang mga address ng akusado, sila Raimunda at sila Mario Basa, hindi ba?
Opo.
At ang kanilang address po ay Libis, Quezon City, hindi po ba?
Opo.
Opo. Eh yung writ of execution po ninyo at ang notice of garnishment, sinerve po ninyo sa 901 Lepanto Street, Sampaloc, Manila. Tama ho ba yun?
Tama po. Kasi po, sa mga returns po ng mga order ng court sa mga notices, yung returns po dun unknown na yung mga akusado sa lugar na yun.
May itanong ko po, Sheriff, sino po ba ang nagsabi sa inyo na ang Basa Guidote Enterprises na ito ay nasa 901 Lepanto Street, Sampaloc, Manila? Ang private complainant po ba dito, si Cristina Corona?
Opo, ang sabi ko ata dun yung lawyers nila.
Ang lawyers ni Cristina Corona. Natatandaan niyo po ito, tandang-tandaan ninyo. At ito po, Sheriff, ay tinanggap nyo na hook, line, and sinker, kumbaga, yun nga ba ang ating, yun bang ibig nyong sabihin?
Ang galing po.
Na ang Basa Guidote Enterprises ay nasa 901 Lepanto Street, Sampaloc, Manila.
Yun po ang binigay ng information nila.
Hindi na po kayo nagsiyasat sa ating Securities and Exchange Commission kung saan nga ba talaga itong sinasabi nilang Basa Guidote Enterprises, Inc.
Hindi na po.
Hindi nyo po nalaman na ang Basa Guidote Enterprises, Inc. ay nasa 903 Lepanto Street, Sampaloc, Manila. Hindi nyo nalaman na yan.
Hindi ko na.
Dahil hindi na kayo nagsiyasat sa SEC, hindi po ba?
Hindi po.
Kayo ay naniwala na sa mga abogado ni Cristina Corona.
Opo, at saka po, nagbigay naman ng sumagot po doon sa notice of garnishment po yung Assistant Corporate Secretary ng Basa Guidote.
Ito po ay si Cristina Corona.
Opo.
Sinabi niya sa inyo na siya ay Assistant Corporate Secretary.
Sabi po,
sabi niya.
Sa records po.
Oo. Hindi niyo na rin ito inalam sa SEC. Natotoo nga ba kaya siya ay Assistant Corporate Secretary?
Hindi ko na po inalam.
again, you accepted it, hook, line, and sinker kung ano ang sinabi sa inyo ni Ginang Corona.
Dahil,
Opo. Anong sagot po ninyo, Sheriff?
opo, dahil yung sinabit niya pong record sa office, sa court.
Ngayon, nang nagpunta po kayo dito sa sinasabing Basa Guidote Enterprises Inc., 901 Lipanto Street, Sampaloc, Manila, sasang-ayon kayo po sa akin na ito po ay hindi opisina, di ho ba?
Hindi, matagal na po, pero yun nga, panulumang bahay siya.
Lumang bahay. Hindi nyo po ba napag-alam o sinabi man lang sa inyo ni Ginang Corona na yung 901 Lipanto Street, Sampaloc, Manila ay yun ang bahay, lumang bahay o ancestral house nung kanyang mga magulang? Hindi po ba niya sinabi sa inyo yan?
Hindi niya po sinabi.
So pagdating nyo po doon sa lumang bahay, sa 901 Lipanto Street, wala kayong nakita doon nakaratula na Basa Guidote Enterprises.
Hindi ko na po matandaan kung mayroon man o wala.
Okay. So wala rin kayong mga nakitang mga empleyado doon o mga office workers doon, di ho ba?
Ang lumabas na po nga yung caretaker po.
Caretaker.
Kung
Ito po ba ay si Celebrada si Pardines?
o yun po, yun ang pakilala niya sa akin.
Pakilala niya. At hindi niya kilala kung sino man, kung sino si Jose Maria Basa III, di ho ba?
Pagkatanda ko po, ang sabi ko niya, bihira na pumunta doon. Parang gano'n.
At hindi taga doon si Jose Maria Basa, sinabi niya sa inyo.
Hindi niya ko sinabi yun.
Sheriff, hindi po ba pag ang sinasabi ng ating revised rules of court na pag shares of stocks ang ating i-implement or ang ating igagarnish, dapat susundin natin ang Rule 57, Section 7, Paragraph C. Basahin ko po sa inyo dahil baka hindi po ninyo naaalala. Stocks or shares or an interest, basahin ko muna po ito. Section 7, attachment of real and personal property recording thereof. Real and personal property shall be attached by the sheriff executing the writ in the following manner. Letter C, stocks or shares or an interest in stocks or shares of any corporation or company by leaving with the president or managing agent thereof a copy of the writ and a notice stating that the stock or interest of the party against whom the attachment is issued is attached in pursuance of such writ. Ang tanong ko muna, preliminary sheriff, hindi po ito ang unang pagkakataon na kayo po ay naggagarnish ng isang shares of stocks o nagli-levy ng isang shares of stocks. Hindi po ba?
Objection, Your Honor.
What is the,
Misleading, Your Honor. The rule pertains to attachment.
what is the misleading?
Your Honor, the rule cited by counsel is the rule on attachment. The sheriff is testifying on execution. These are two entirely different rules.
Your Honor, the revised rules of court provides that if the property to be levied is a personal property or a shares of stocks, Your Honor, it specifically says that it will be attached in accordance with the same rules that provides for the preliminary attachment. That is basic. I can cite the rule.
Objection overruled.
Thank you, Your Honor.
The levy,
So may tanong po ako, Sheriff. Hindi ito ang unang pagkakataon na kayo po ay nag-levy ng shares of stocks ng isang kumpanya sa loob ng inyong 16 years bilang isang sheriff.
The question is vague. Levy under what? Levy under execution or levy under attachment? Because levy is
I will clarify again. Your Honor.
may I,
kindly clarify.
may I request the counsel to let the question to be finished?
Yes, Your Honor. I will clarify.
Oh, thank you.
Hindi po ito ang unang pagkakataon, Sheriff, na kayo ay nag-levy by execution ng shares of stocks ng isang kumpanya. Hindi po ba?
Sa pagkakatanda ko po, ito ang first time na shares of stocks.
Sa loob po ng 16 na taon, ito po ang unang pagkakataon, Sheriff.
Sa pagkakatanda ko po, Ben.
Sa pagkakataon. Maaaring may nangyari na in the past pero hindi nyo na natatandaan. Tama po ba yun?
Wala ko akong matandaan.
Wala kayong matandaan. Now, ang sinasabi po dito sa binasa ko kanina, paragraph C of section 7, rule 57, na ang levy ng shares of stock ay dapat iniiwan po ninyo sa presidente or managing agent ng kumpanya. Dito ba sa inyong notice of garnishment, kanino po ba ninyo iniwan ang notice of garnishment?
Again, with the kind indulgence of this Honorable Court, Your Honor, we have objected to this question because the provision of law cited is levy under attachment. This is not an attachment, this is levy under execution, Your Honor, and therefore is governed by Rule 39, Your Honor. There is entirely a lot of difference, Your Honor. In attachment, it's preventive. In levy under execution,
Let the prosecution answer that objection.
Yes, Your Honor. I will cite the rule, Your Honor. Hindi.
Sandali, wala. Wala na naman. Oh, yung apel. Hindi, yung rule. Yan. Oh, ayan, pero sa attachment. Oh, against whom the attachment is issued. Oh, saan dun yung rule? Ayun. Hindi, yung attachment. 57. Hindi ako marunong nito. Ayan. Ayan, preliminary attachment.
Kailan ba in-appoint si
Now, to buttress, if Your Honor, please, may we go a little further with the kind permission of the court?
Proceed.
Your Honor, please, may we invite the attention of the Honorable Court, Your Honor, that Rule 57 is strictly applicable only in cases of preliminary attachment. The formalities therein referred to refers to attachment. And what we have in question now is not an attachment, but a levy under execution. So the formalities required by Rule 57 does not apply in cases of execution, Your Honor. Our point, Your Honor.
That is why I'm asking the counsel to answer you. So
Yes, Your Honor.
Thank you, Your Honor.
It is found, Your Honor, in Section 9, execution of judgments for money, how enforced. And this is under paragraph B, satisfaction by levy, Your Honor. And I direct, Your Honor, the attention of the esteemed counsel of the defendant on subparagraph 4, Your Honor, and it states, I read it for the record, real property, stocks, shares, debts, credits, and other personal property or any interest in either real or personal property may be levied upon in like manner and with like effect as under a writ of attachment.
All right.
So maybe Justice Cuevas have forgotten his rules, Your Honor.
I have been teaching the subject for no less than 3 decades, Your Honor. And the law is very, together with the jurisprudence, and the point is very specific. You do not apply the rule on attachment. What the law simply means by the levy could be effected similar to that of attachment is merely an analogy of the process that will have to be undertaken. But definitely, attachment, the rules on attachment does not apply in execution.
At any rate, this will be evaluated by the court.
Yeah, but we...
What is material here is just testing the credibility of this witness. Because even the court is interested to find out whether indeed there was machination in the, to be frank about it, whether there was machination in the sale of these shares.
Yes, Your Honor, we are very appreciative for the court going that far.
That is the understanding of this chair with the tendency of the questions.
But if the court will notice, Your Honor, and with the kind indulgence of the court, the question before was predicated on Rule 57, not on this particular rule that he is now citing, Your Honor.
Anyway, let's not wrangle on this. And we are all intelligent people. We will take that into account. Let the witness answer.
What is the question now?
Ang tanong ko po sa inyo, Sheriff, ay yung notice of garnishment po ninyo na naka-address po dun sa Basa Guidote Enterprises ay hindi po na-serve sa presidente o sa managing agent nito, hindi po ba? So, dapat at ang totoo ay sa isang, sabi ninyo, caretaker lamang ng bahay na iyon.
Opo, pero
Salamat po, opo.
may sumagot po na anong officer ng Basa Guidote.
Yun. Pupunta po tayo doon. Pupunta po tayo doon, Sheriff. So pagkatapos po ninyong may serve ang notice of garnishment, ang sabi po ninyo ay may sumagot na officer, quote-unquote, ng Basa Guidote. Ito po ay si Cristina Rocco Corona, Assistant Corporate Secretary, sa pamamagitan ng isang sulat na ibigay sa inyo. And this was marked by the Defense, Your Honor, as Exhibit 179.
Opo.
Salamat po. At hindi po ba, Sheriff, at alam ninyo na si Cristina Rocco Corona ay siya rin ang private complainant sa kasong ito.
Opo.
Siya rin ang inuutos ng korte ng Branch 216 na babayaran kung sakaling marirecover ninyo yung 500,000 piso. Di po ba?
Opo.
Ngayon, Sheriff, dito sa reply ni Ginang Corona, ang sinasabi sa inyo, and I would like to quote it for the record, Your Honor, if I will be allowed. In reply to the notice of garnishment dated May 14, 2003, please be informed that based on records submitted by the accused in court, the stock holdings claimed by Jose Maria Basa III and Raimonda G. Basa in Basa Guidote Enterprises, Inc. are as follows. Stockholder, Raimonda Basa, number of shares, 110, amount, 11,000. Jose Maria Basa III, number of shares, 4,729, amount, 472,900, or a total of 4,839 shares in the amount of 483,900. Ang tanong ko po sa inyo, Sheriff, nung ibinigay po ito ng Ginang Corona, ito po ay tinanggap nyo na as gospel truth?
Dahil wala namang, sila kung title niya doon sa korporasyon, wala na akong dahilan para hindi paniwalaan. No?
Hindi po kayo nagpunta sa Securities and Exchange Commission?
Hindi po.
Sheriff, hindi po ba sinabi sa inyo ni Ginang Cristina Corona na siya ay nag-file ng isang petisyon sa korte, sa probate court, na ang sinasabi niya sa korte na iyon, ang nagmamay-ari ng shares of stocks or about 87% ng shares of stocks ng Basa Guidote Enterprises ay ang kanyang lola, si Asuncion Rocco. Hindi po ba sinabi sa inyo ito?
Before the witness answer, may he be served with a copy of the alleged pleading, Your Honor. It's an alleged statement of fact appearing in a pleading, Your Honor.
If
It's premised.
if the prosecution has, please show the pleading.
We reserve, Your Honor, the voluminous records that we have. Unfortunately, we didn't bring the petition for probate, that it is a fact, Your Honor, that there was a probate.
With the kind permission of the court, therefore, we will move to strike out the question, Your Honor.
Let it stay in the record.
Mr. President, may we recognize Senator Lacson?
I'm sorry to interject, Mr. President. Interesado lang po ako, ito bang mga kapanahon na napag-uusapan natin, kung alam ng counsel ng prosecution o ng defense, may katungkulan po ba sa gobyerno si Chief Justice Corona? Siya po ba'y private citizen or kung may katungkulan man, ano po ba ang katungkulan niya? Ito mga panahon na ating dinidiscuss sa ngayon.
Mayroon na pong katungkulan.
Ano po yun?
Noon pong 2001 ay naging Assistant Presidential Legal Counsel po, kung hindi po ako nagkakamali.
Ito pong panahon ng may mga writ of execution. Ano po ang katungkulan niyo kung meron
Katungkulan na
man?
po niya, siya na po ay isang Associate Justice ng Supreme Court po.
Maraming salamat po.
Sheriff,
Po.
anong bang nalaman ninyo na yung nangangatawan ng korporasyon Basa Gidote ay isang babaeng nagngangalan Cristina Corona? Alam ba niyo kung ano ang kanyang relasyon sa Justice Renato Corona ng Korte Suprema?
Nung panahon po yun, hindi ko po alam na ano, nung unang panahon yun.
Hindi mo alam nung panahon na yun.
Hindi pa po ako.
Sige.
The defense, Your Honor, is asking for a copy of the petition in the matter Asuncion Basa Rocco and Cristina Rocco Corona, Special Proceeding Number 95-76-331, and Raffle 2 and assigned to Regional Trial Court Branch 12 of the Regional Trial Court of Manila, Your Honor.
Hindi po ako, with Your Honor, please, with the kind indulgence of the court. I'm not asking for a copy. Since the cross-examination question is predicated on knowledge pleading, it is our stand, Your Honor, that in accordance with the rules of evidence, the document must first be shown to the witness, allow him to read before he answers, Your Honor.
Thank you, Your Honor. We will now allow the witness to...
Alright.
So, Ginoong Sheriff, pinapakita ko po sa inyo itong petition.
Is instructed to show the document to the witness.
Yes, sir.
Hindi po ba, ang tanong ko po sa inyo kanina, hindi po ba sinabi ni Ginang Corona na siya ay nag-file ng petition na ito sa Regional Trial Court of Manila, and in that petition, she claimed that Asuncion Rosario that Rosario Gidote Viuda de Basa is the owner, and I would like to quote, Your Honor, paragraph 3 of the petition. The estate of the testatrix consists of personal properties in the form of 4,665 shares of stocks in the corporation registered as Basa Gidote Enterprises, Inc., of which only 70 shares were disposed of as legacies in her will and the household furniture in her residence. The date of the petition is November 29, 1995.
At this juncture, Your Honor, we will most humbly request that the question be simplified. It's loaded with several subjects. Hindi ho ba sinabi sa inyo ni Mrs. Corona? Then several other subjects. It cannot be answered by plain yes or no, Your Honor.
Reform your questions, Counsel, so that there will be no further objection.
Okay. Hindi po ba sinabi sa inyo ni Cristina Corona na siya ay nag-file ng petisyon sa Regional Trial Court Branch 12?
Wala po siya nabanggit sa akin.
Hindi po ba niya sinabi sa inyo, Ginoong Sheriff, na sa petisyon po na yon ay sinabi niya sa korte at pinanumpaan niya bilang petitioner na ang nagmamay-ari ng 4,665 shares ng Basa Gidote Enterprises, Inc. ay ang kanyang lola na si Rosario Gidote Viuda de Basa. Hindi ba niya sinabi sa inyo yun?
Wala po siya nabanggit.
Sheriff, mayroon akong ipapakita sa inyo sa pages 3 at saka hanggang pages 8 ng certified true copy ng petition na ito. At pakitingnan nyo nga po ninyo, Sheriff. Pakibasa nga po ninyo, Sheriff, kung ano po ang nakalagay dyan. Opo,
May we know what the document is all about?
petition.
The
or
petition for the probate.
And what is the question now? If Your Honor,
If
please,
he
can you
knows,
put the
Your
question
Honor.
now?
If he knows what is written on the petition, Your Honor, if he can read.
Hindi ko mabasa masyado.
If he knows what is
Hindi ko maliwanag.
Hindi mo babasa?
Medyo malabo po.
Ha?
Yes, Your Honor. We would like, Your Honor, to manifest that on pages 3, 4, 5, 6, 7, and 8 of this page, on the top page, Your Honor, it appears to be that this is a facsimile copy, Your Honor, but it is certified true copy by the Regional Trial Court, Branch 12. And it came from the office of Secretary R.C. Corona, Your Honor. We would like to mark, Your Honor,
What does it say?
it is a fax document, Your Honor, a copy of the petition, and it came from the office of Sec R.C. Corona.
Show it to the,
But what?
show it to the defense so that they will,
But what is it, Your Honor, and what is the question now?
well, let the document be shown to you first, and then,
Pinipilit. Ayan. Ayan daw. This is a copy of the document. What is the point?
Mark, ano nang exhibit tayo?
Hindi natin masabi. We are not familiar with it. We are not counsel for the court.
Yes, Your Honor, may we request for...
Mr. President,
yes,
may I, while they are looking over the documents, I move that we suspend the trial for 15 minutes.
right, session suspended for 15 minutes.
relevance nito dito sa aming purpose, doon sa kadahilanan ng pagpipresenta namin ng testimonya ng aming testigo? Ang sagot po namin, wala. Sapagkat at that point in time, kung talaga pong namatay ng pagkakataon na yon, yung akusado, they have the available remedies na maaari po nilang gawin upang ihinto or i-reverse yung desisyon ng korte, ihinto yung execution. Kung wala hong ginawa yung akusado o ang kanyang pamilya, hindi naman ho dapat ito isisi pa doon sa nanalong litigant, ano? Sa ordinaryo hong proseso, pang araw-araw ho, nakikita ho natin na ganitong ginagawa. Bakit ho ba pilit na lahat ho isinisisi sa pamilya Corona? Kung meron ho silang hindi ginawa at that point in time, that is their own lookout. But for them to question the validity of a final and executory order or decision of the trial court, ito po yung nagpapakita sa kanilang insensitivity. Ito po yung nagpapakita sa walang tiwala at walang pagrespeto po doon sa ating mga korte. At yan naman po yung hindi namin hinahayaan.
Ayun po, kapag patay na po ba yung defendant, pwede po ba siyang kasuhan? Defendant, kapag namatay na.
Okay. Hindi po patay yung dinimanda. Siya po'y buhay na buhay nung nagsimula po ang kaso. Namatay lang po siya nung, kung tama po ako, nung magkaroon na ng desisyon. So, liliwanagin ko po, ano po ba mga batas na sinasakop nito sa ganitong mga usapin na may namatay? Kung purely civil po ang kaso, meaning walang kriminal, nasa Rule 3, Section 16 po yan. At ayon po doon, pag namatay, buhay pa rin po ang kaso. And there is what you call substitution. Pwede pong may pumalit doon. Meron rin po na provision yan sa criminal procedure, sa Rule 113. Ang ibig po sabihin nun, paano po kung may namatay? Generally po, pag may namatay, dahil nga tao, bangkay na siya, wala na rin po ang criminal case. Tama po ba yon? Ngayon po, kung meron po mga ibang kaso na offshoot po, na hindi nagmumula doon sa krimen na yon, ay buhay pa rin po iyon. At pwede pa rin pong ituloy iyon. Ngayon, siguro po ang tanong ng abogado kanina is paano, patay na, pwede pa bang mag-execute? Tanong niya yun. Pwede pa bang mag-execute? Patay na? Wag ho akong pakinggan nyo. Nasa Rule 39 po yan, Section 7. Ibig po sabihin, pagpatay na ang obligor or yung may pagkakautang o sinabi nga dapat magbayad, yun po ang provision na mag-a-apply. Pwede pa rin po. Ngayon, medyo po masalimuot po ito eh. Kaya po masalimuot, alam niyo po kung bakit? Kasi binipilit nilang suriin ang isang kasong tapos na final executory. And ina-attack nila collaterally dito sa impeachment court para i-discredit yung tao. Ang clerk of court po, umupo lang doon para patutuhanan, meron pong desisyon. Ito pong desisyon, ganito po ang nangyari. Ito pong desisyon, ito po ang naging desisyon, conviction. Wala po siya magagawa. Although, sige, pwede mo siyang presentahan, tanungan, pero wala na pong mababago ron. Unless na gumamit sila ng remedyo na ayon sa batas. Hindi, katulad po ng sinabi ng aking kasama, yung mismong interesado hindi nag-appeal eh. Wala hong remedyong ginawa. Pati nga po hanggat dito po yung inaction or kakulangan ng pagkilos nung mga na-convict, ay isinisisi pa rin sa mga Corona. Di po ba? Ito po ay, kung babalikan ninyo, is more than 10 years ago. Isang dekada na po. Tapos dahil sa hindi pagkilos ng iilan, sino po may kasalanan? Corona pa rin ay may kasalanan. Yun po ang mabigat doon sa kalagayan namin po ngayon.
Had to be paid and they try to raise the amount by sharing the shares, tama po. And then ang bumili po ng shares yung anak po nung, hindi po ba medyo kakaiba yun? Is it done to take over the company?
Hindi. Kasi kung tatandaan ninyo, public auction to. Ibig sabihin, pag sinabi mong public auction in accordance with the rules, ina-advertise pa nga yan eh. Para kung sino interesado, yun ang bibili. Pero ang tandaan ninyo, itong korporasyon na to is not listed. Hindi siya yung katulad ng mga korporasyon na nakikita natin sa stock exchange. So, close family corporation to. Kung ikaw rin yung bibili na stranger ka, ibig sabihin wala kang kinalaman sa korporasyon, hindi ka rin siguro interesado kasi isipin mo, hindi ko alam paano pinapatakbo tong korporasyon na to. Hindi ko alam kung kikita ba ako pagka nag-invest ako dito. So, siguro kaya yun yung dahilan. Walang gusto mag-bid at mababa yung bidding price.
Pero kung tatandaan nyo rin dun sa testigo, yung value nung judgment was 500,000. Magkano lang nabili yung shares? 28,000. So, ibig sabihin, hindi enough yung binayad nga dyan sa auction para ma-cover yung judgment. So, kaya sabihin nyo, bakit parang ang baba lang ng pagkabili? It's because yung kino-cover niyang amount for the judgment is very small. Kaya, siguro hindi kakaiba dito na tinanggap din yung presyo na yun because related naman doon sa na kumukuha nga, ibig sabihin kung kanino ina-award dapat yung value na yun. So, in any case, hindi unusual to, lalo na close corporation yung involved.
So through the sheriff, we want to prove that the shares really belong to the daughter of Chief Justice, and therefore this need not be reflected on his salin. Parang ganun po.
More of dito, makikita natin, kasi isa rin sa mga siguro katanungan dati na assuming nga na nakapag-utang sa Basa Guidote Enterprises, isa pa yung related na fact dito, yung kung may 11 million pesos na inutang, paano na utang? Kasi nga, di ba, makikita nyo sa mga pahayagan, sinasabi ng mga Basa, pamilyang Basa, hindi namin alam na nakautang sila. Because by then, iba na yung majority owner. Nung umutang, ang majority owner na halos may-ari na ng buong korporasyon dito ay si Carla Corona at si Mrs. Corona, at meron pang mga papatunayan eventually dito yung mga resolution nga na nagbibigay ng kapangyarihan na magbigay ng gumawa ng transaksyon na may kinalaman sa Basa Guidote Enterprises. Kaya ngayon cheque na binayad ng City of Manila, naka-address na lang kay Mrs. Corona as trustee for Basa Guidote Enterprises. So, yun yung makikita nating unti-unting nabubuo yung storya in relation to the salin.
Karagdagan lang, yung dadagdagan ko lang yung katanungan mo doon sa public auction. Walang masama na yung relative ay mag-purchase doon. Kasi nga public Kung sino pong interesado ay pwede. Makikita nyo nga po kung ang bangko ay nagpa-public sale, execution. Yung bangkong nagpautang ang mismong bumibili po noon para mabayaran. So wala pong kakaiba noon. At tingnan nyo po, ang sheriff dito ay umupo at inupo lamang para totohanan may nagbenta ba, binenta ba, nagkaroon ba ng public sale. Yun lang ang dapat niyang patotohanan dito. Pero po makita nyo, layo na ng inabot natin. Pati yung mga proceedings na hindi man lang alam ng sheriff ay itinatanong, probate, talaga po hindi alam ng sheriff yun. Kasi hindi po pasok sa husgado niya yun Ang trabaho po ng sheriff ay ministerial. Wala po siyang discretion, ito po ang inutos ng batas sa kanya, ito po ang gagawin ko, itong ibebenta ko. Ganun po yun.
Sir, just to backtrack a little, kailan ho nangutang si CJ sa BGEI?
Kung tama ho ako, parang 203, Parang I'm not too sure, 2002, 2003, mga ganun po. Nakadeklara naman ho yan sa SALN May kita nyo yon pag binalikan ninyo, meron naman kayong kopya na nakalagay po doon 11 million po. Nakalagay naman
So,
po doon.
2003.
Mabe-verify nyo naman po sa records.
Kailan ho nagkaroon ng bentahan ng shares? Kailan binili ni Carla yung shares?
Para nga kung tama yung pagrinig ko kanina September 2003 rin po.
2003.
Yes, opo.
Pero
Atin pong napanood ang bahagi ng press briefing na kasalukuyang isinasagawa ng defense team.
This is turning out to be a very interesting day at mukhang merong magandang nangyari sa araw na ito. Mga detalye nitong Basa Guidote case ay lumabas. In fact, some viewers are finding this very interesting.
Pero medyo maraming teknikalidad din, Mark, kaya kasama natin pa rin si Attorney Revilla para i-explain sa atin itong mga naganap dito sa paglilitis ngayong hapon. Isa pong mahalagang pinupunto ng prosekusyon dito sa mga testimonya ng dalawang
presented contains certain words appearing to be the sender of a facsimile. Now, we have no quarrel over the letter of those words. We are curious, however, what is the point? Why, first place, this is a mere photocopy. It is not the facsimile itself. But we're also curious why he wants us to introduce this into the case at this point. The pleading is not has no relevance to the SALN or to the issues conveyed to us by the court yesterday. Secondly, it is not clear where this document came from and to whom it was sent.
The prosecution may reply.
Thank you, Your Honor. First, Your Honor, this is where it came from. This is a certified true copy, Your Honor, by the Regional Trial Court. And this is signed by the Clerk of Court of the said branch, Your Honor, dated March 21, 2012.
It's a part of the court record.
Yes, Your Honor, part of a court record, Your Honor. And as for the purpose, Your Honor, why we are presenting them and marking, we will make a formal offer when the time comes, Your Honor. So may we request, Your Honor, that this petition, Your Honor, be marked as our Exhibit 11U, Your Honor.
Your Honor, before the court grants the request, may we know from which RTC branch the counsel is referring to? And may we know if this is exactly a reproduction of the document that appears in the file of the RTC, or a mere certification that this is a copy of the contents of the pleading?